Welcome to another episode of the Law with Darren podcast. So today I want to talk to you guys about a very common situation that I have with my clients. So almost every day when I call my clients and I explain to them that I got them a good offer on the case, and then I tell them what the offer is, and I walk them through the attorney's fee and the case expenses, I get to the part of the case or the settlement sheet where I tell my clients, okay, great, and, we only have to pay back this amount of medical bills to your chiropractor or the hospital or your health insurance company. And then immediately, a lot of my clients will say, whoa, wait a minute, Darren. I have to pay back my medical bills when he hit me? That's not fair. Why should I have to pay back my medical bills? And it does sound a little backwards. I do understand why people could feel that way, but it actually makes sense. And here's why. So lawyers settle cases without going to trial because it makes sense. It makes sense for all parties involved. If the case is a slam dunk, if you're rear-ended and you go to a chiropractor or a physical therapist for 10 weeks and you go to the hospital, it's pretty simple that if you go to trial on that issue, that a jury, I would hope, would give you everything. So that's why cases settle, because what's the point of going to trial and wasting money if we can all just go home happy as it is? So in a perfect world, or in a traditional sense, if you're in an accident, you get hurt, you fix yourself, you fix your car, you go see all your doctors. At the end, when you're all done, your doctors clear you, you call your lawyer and you say, okay, I'm all done with my doctors, I'm healed, I'm feeling great, I'm back at work, everything's good. At that point, your lawyer could file a lawsuit suing the person that hit you. You go to trial. You try the case to a jury. You put in the evidence of your medical records. You put in the evidence of your medical bills. You would testify as a plaintiff to your lost wages and your pain and suffering. And then at the end of the case, the jury would say, okay, we've heard the evidence, and yes, we believe that your $10,000 in medical bills are absolutely reasonable and necessary. Your $20,000 in lost wages makes sense to us. We agree. We can absolutely see ourselves in your shoes in that situation. And your pain and suffering for the 5 months that you were injured, as evidenced by your treatment, is worth, $8,000. Whatever the jury wants to find. And therefore, we're going to award you $30,000. Now, that's the traditional, very nuts and bolts way of how it works. And then the judge says, thank you, jury. You're all set. You're dismissed. Go home. And then the judge signs a piece of paper called a judgment ordering the defendant to pay you $30,000. Now, what happens now is that all of the medical bills that you as a plaintiff just put into evidence saying that you have accrued or that you have to deal with because of what the defendant did to you, you have to pay for those, right? Because you just told the jury that, hey, I owe $8,000 in medical bills that I got to pay back to doctors. Okay, well, the defendant is not going to pay you the $8,000 that the jury told the defendant to pay you and then go pay the bills themselves on their own. It doesn't make any sense. They would be paying twice. So they're only going to pay the one time. So what does this mean? Well, in practicality, that means that when your lawyer settles a case, typically what happens is you settle the case for the total value, $50,000, whatever the number is, and then you as the plaintiff are responsible to make sure that your chiropractor gets reimbursed, your doctors get reimbursed, and your health insurance gets reimbursed. Okay, so that's really how it works. Now, the other question people try to ask me is, well, wait a minute, I have health insurance. I pay premiums. Why do I have to pay my health insurance back when I already pay them every month to cover me? Well, here's why. To make health insurance contracts affordable, a lot of health insurance companies, what they do is they put little clauses in the policy that says, hey, you pay us premiums, and in exchange, we will cover you and pay your medical bills if you're in an accident or injured. We don't even care if it's because of your own stupidity, like you fall off a ladder at home, putting up Christmas lights. We will pay, no questions asked. You're all set. You don't owe us any money back. Unless, and here's the little caveat, you are injured in an accident and you get money from the person who hurt you for medical bills that we paid. In that case, we have a right under this contract to request that you reimburse us. And that, ladies and gentlemen, is why the health insurance does have a right under the contract, which is the insurance policy, to request that they be reimbursed for some of the money that they paid. So I hope that makes sense, okay? And it gets even more complicated and more solidified when you're dealing with like Medicare. Federal Medicare, they don't care. They have a super lien on everything. A lot of Medicaid, so like state Medicaid, neighborhood health plan in Rhode Island, Mass Health in Massachusetts, Connecticut has Husky. Those are all Medicaid programs. They also have liens not only by the contract, which is the policy of insurance that covers you, but by the actual state legislature, the state law that makes it extremely difficult to try to argue that you do not have any obligation to repay. And if you don't pay them, they could try to sue you, and they could also try to sue your lawyer. And your lawyer does not want to get involved in that kind of litigation. Trust me. So I hope it makes sense, guys, why, your lawyer may tell you at the end of a case that, they got you money and you as a plaintiff, have to deal with medical bills. And a lot of lawyers, what they should be doing is they'll already have all of the agreements in place with any physical therapist or doctor's offices, agreeing to accept a certain amount of money to wipe out your balance. Hopefully your lawyer doesn't say, okay, here's my cut, here's your cut, go call your 20 doctor's offices and deal with these collection issues. That's really a scummy way to practice law. So if your lawyer does that, I wouldn't really call him a good lawyer for that reason. So hopefully you guys enjoyed. Hopefully it makes sense. If you have any questions, please feel free to like, comment, subscribe. And until next time, be well, be safe, and take care of yourselves.